Welcome back, everyone. We're kicking off today's docket with a wild mix of cases from probation violations to battery and bond reductions. Right out the gate, the courtroom is buzzing with tension. Judge Boyd sets the tone with a packed calendar and sharp focus. If you've ever wondered how a courtroom manages a full docket in real time, you're about to witness the raw pace and pressure of justice on display. Let's see who's stepping up first and whether they're walking out or staying put.
Charged under a prosecutor's deferred.
The next part, Your Honor.
Prosecutor's deferred. Yeah, have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
State your name.
Travis Southbury. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a...
Here comes Daniel Bernstein. He's facing a plea hearing and Judge Boyd wastes no time. You'll notice how quickly they move through the formalities because this isn't his first appearance. When the judge confirms his understanding of the plea deal and outlines the sentence, Daniel's short responses speak volumes. This is a man who knows what's coming, and likely knows he's lucky to get probation instead of jail time. But as always, there's more beneath the surface. Stay tuned.
This charge. You understand that? Yes. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Yes. All right. Basis for the no contest plea, counsel.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
You understand that with pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 25-1258. Any objections to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report and also the court having heard the testimony in this case, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be.
Let's pause here. That 10-year probation might sound lenient until you realize what it actually means. 10 years of walking a legal tightrope. One missed check-in, one bad decision, and Daniel could end up serving the full prison sentence. That's the gamble in these plea deals, freedom but with strings attached. And Judge Boyd makes sure everyone understands those strings are tight.
Court does call the case of the people versus Stephen Grisvick.
Alexander, on behalf of the people, Your Honor. It is Mr. Burns. Do you want to go check the hallway?
Or you could just sit there. Either way.
I just saw him.
He was just back there.
Maybe he went so bad.
Like this happens every time my case gets called first.
Yes.
So here with and on Sam Bernstein with and on behalf of Mr. Grzybek, who's present with me.
Your name, sir.
Stephen Grisbeck.
All right. Go ahead.
Here for sentencing, Your Honor. We were here last week when everyone very graciously and patiently listened to me ask for possible sentence where Mr. Grzybic would do the accountable choices program in jail with, release on a tether to probation afterwards. And I appreciate Ms. Pilara and Ms. Senda for listening to me, and Your Honor, of course. Mr. Grzybic has been trying to get into that program since he got into jail, but he's been really pushing.
And here's where it gets interesting. Judge Boyd calls out a miscommunication. Apparently, the state was under the impression this was a different type of hearing. You can almost feel the air tighten as the attorneys scramble to get on the same page. Missteps like this may seem minor, but they can derail entire plea deals. Credit to the judge for keeping everything moving despite the hiccup. A lesser courtroom might have reset the hearing entirely.
To get in there, he'd be doing a significant amount of time before completion. One of the things I've been talking to him that he's concerned about is his Section 8 voucher. He's worked very hard to get it, and he's about a month away from potentially losing it. Maybe a month and a half that he worked very hard to get, and he does have a job for the meantime, but we don't know how long with heating and cooling. That it's been a pretty good job for him. So he's gotten some strides going in his personal life that he stands to lose. And I think maybe he could have held it together if he thinks accountable choices would start in the short term, but I just don't know that it is. So I guess we are asking the court to consider maybe like a release to drug treatment in the interim. To get.
How long is the program, the in-jail program?
I think it's 13 weeks, Your Honor.
Okay. Did they, did they tell you, Mr. Griswold, you were 52 ahead of you?
Yes, because I wrote a kite and they came back Thursday night and told me that there were 52 people ahead of me. That's with being court orders.
Got it.
So there's 52 people ahead of me.
So those were 52 that had not started it yet.
I had not started it yet.
Okay. Well, I guess what I'd probably do is order this. I will, if we can find an alternative program with him out that would work for him, then I might consider release.
Your Honor, I can tell you that the program, the in-jail program, is offered out. And in my recommendation, I was asking the court to have him complete the first phase in and then continue the full programming out. So that is how.
That's how it's structured. But I guess my question is it gonna take him, does he have to wait through 52 people to do that? And
On the
then,
outside, no.
pardon?
On the outside, no.
Right,
It's a
but
52-week program on the outside.
gotcha. But you want him to do the first phase of the DV program in jail, but he won't at best get to that. I mean, I don't know how many people are in the class, but he won't get to that at least for 13 weeks, probably much longer.
If the court is considering to release him so he can get started with that program on the outside, I would ask that he definitely have that GPS monitor on, so he can do that.
Let's do this. So, Mr. Wilson, did you verify that it's 52 ahead of him?
I have not verified, Your Honor. Mr. Grzybic just told me. I'm happy to, I can email Mr. Henderson who runs the program or Lieutenant Arnett. Get like a
Here's
better.
what I'll do. I'll order what's here. I need it then checked
Okay.
as to how long it's anticipated before he would get in.
Yes.
And then I'll consider changing the program so that maybe he can complete part of that outside or complete it outside as opposed to in.
That makes sense. I appreciate that, Your Honor. And I'll send some emails right after court.
All right. Anything else you want to say before I impose that?
No, Your Honor. I don't know if Mr. Grzybic had a couple of things he wanted to say.
I would like to say, Your Honor, I want to take accountability for my actions and I apologize to the courts for going through this. And I just received my Section 8 housing voucher back in November. And I just got it. And if I do any more than like a month in jail, I will lose my Section 8. And I'm just asking the courts if I could do this class and with one, if I, I won't.
Next up, Anthony Chambers. The minute he steps forward, the mood shifts. This isn't a routine hearing, this is a bond reduction request. Chambers is asking the court for a second chance after sitting in custody, hoping the court believes he's not a flight risk or a danger. Judge Boyd gives him space to speak, and Chambers gives us a rare glimpse into the personal toll of pretrial detention. These moments, they're what make courtroom footage so compelling.
Not get in any more trouble, and that if I complete this class, that it'll make me even better person for today. I want to show the courts that I can do this.
All right. It's a sentence of the court, place you on 24 months probationary term. You're to pay $555 fines and costs, 720 probation oversight fees. I'm going to make that due and payable 45 days after release.
Emails out.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-jail DV program, phase 1, and then remainder of the program, phase 2, after release. That's what I'll order at this time. And again, I would potentially change that if necessary, once we can take a closer look at when he can get in.
But let's be clear, bond reductions aren't handed out like candy. The court weighs risk, past behavior, and the seriousness of the offense. Chambers' case includes allegations of battery and resisting arrest. That's serious. The defense argues for a lower bond, highlighting stability and ties to the community. The prosecution pushes back. Judge Boyd, he's listening carefully. One misjudgment here, and the consequences could be devastating.
Probation as requested by probation, including any home visits. Begin and maintain employment with verification to probation. You are to comply with any circuit court orders. I'll set a review hearing that's to be held July 7, 2025, 1 p.m. I will order 365 days in jail. Credit 40 days served. Defendant to remain in custody until completion of the in-jail Dawn Farm program, or not Dawn Farm, DV program. And then the balance will be suspended with placement on a GPS tether prior to release. All right.
Thank you, Your Honor.
All right. Thank you. Can you grab a phone? Court does call the case of the people versus, is it Cyan Taylor?
Haley Zend on behalf of the people, Your Honor. Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are here for a pre-trial. I'd first ask to address bond, please.
You can go ahead.
Ms. Taylor is being held on a $25,000, 10% bond. She failed to appear at a final settlement conference. I am asking that the court consider reducing her bond to a personal bond.
Now we shift to Natasha Odell. She's here for a probation violation hearing, and this one's a doozy. Odell is alleged to have picked up a new battery charge while already on probation. That's a double hit. If true, it could send her straight to jail. This is where Judge Boyd plays both investigator and referee, confirming facts, verifying charges, and deciding whether Odell deserves another shot or a probation revocation. The stakes don't get much higher.
She also, at that time, wasn't working. She now has a job at Home Watch as a nurse's aide. She spoke to her mom, who spoke to that, and she will be able to return to that job if released. At final settlement conference, the people were unable to proceed. However, because she was there or not there, the warrant was issued. I don't know if circumstances have changed with the complaining witness at this point, but our intention is to set up her final settlement conference again, depending on the bond, I suppose. But I am asking the court consider changing the bond. She's been in custody now for over a week. How many days?
A week and 3 days.
11 days now.
that she's been in?
Yes.
All right. Well, how did she come into custody?
I was at the gas station and they said they recognized me, that I had a warrant.
Well, I guess my question is, she missed the court date. Why didn't she come in at some point? Because that was back in October of last year.
Did you have a phone?
Not that, no, not on, no. And also mail was going everywhere else. So it was hard keeping track of everything.
Yeah. I don't think, Your Honor, I think she should have gotten back in touch with us. She did mention to me just now that her, because she didn't have a stable housing situation, she wasn't getting mail, and didn't have a phone, at that time. But now she does have, like I said, stable housing situation, is able to be contacted, about her case.
Any response from the people?
Your Honor, I just have concerns given that this was a failed to appear last year in October and there was no contact with the defendant until she was picked up by police. I'm sure the dates are given, and I'm sure the court is, those dates are given at these hearings. She would have had notice of the date.
Notice how Odell's public defender quickly jumps in to clarify the status of the new charge. It hasn't been filed yet, and that detail could be crucial. If no formal charge exists, the violation might not stick, at least not yet. These technicalities can be the difference between freedom and a cell. This is where legal knowledge really pays off, and Judge Boyd knows exactly how to navigate it.
I want to do better, and I'm not going to waste the court's time anymore. I just want to get back to my job. And I don't know. This was the biggest wake up call I needed, I swear.
June 9th, 2000 at 9 a.m. Set jury selection for June 9th, or June 6th is my jury final settlement cover, correct?
Correct.
So the first date is June 6th, 2025, 9 a.m. Jury selection, June 9th, 2025, 8:30. Both of those proceedings are in-person proceedings. I'll release the defendant on a personal recognizance $25,000 bond. She needs to have a GPS tether for location tracking prior to release. Thank you. Court calls case, People versus Artist Valentine Lewis.
Alexander, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on
Ma'am,
behalf.
did you understand that, what I did?
Yeah, she's gonna be on a tether at my house, right?
Right, but she may not get out right away. They've got to get her over, put a tether on her before she would then be released.
And can I say one thing real quick?
Sure.
I'm not making any excuses for her whatsoever, you know, and she's done like a lot of mess in the last, but last Monday when she came to court, she had a full schedule starting for Tuesday. So I called her job and I let them know the circumstances. And they said that they'll, you know, if she gets out on the 5th, that we'll get back a hold of us. And
Okay,
hopefully she can keep her job.
all right. So hopefully they can get her out.
We're back to chambers, and the state brings receipts, prior failures to appear, violent charges, and a history of non-compliance. Not a great combo when you're asking the court for leniency. The judge is clearly weighing whether Chambers' current request is genuine rehabilitation or just courtroom strategy. And as viewers, we're left asking how much of your past should define your present.
Oh, I'm sorry. I totally butchered your name.
You are.
Your Honor, we're here for a show cause. Mr. Valentine owes $300 on a domestic violence case. He has been in custody for some time.
What does he owe?
Yeah, the $300 is it's a weird number. You did the time on.
No, it's not really, but go ahead.
Well, it's usually if there's the case, they're much higher than $300. He did do 10 months on this case.
Well, hold on. When I issued the warrant for $75 cash. And then his bond now is 1,010%.
Yes, I saw that in JS.
Warrants fee and show costs.
Yeah, that's right. The real
125.
issue, so he's got the statutory $125 fee. He's got warrant fees, which total $100. So that brings.
Let's talk courtroom strategy for a moment. Public defenders here are walking a tightrope. They're advocating fiercely, but they're also realists. They know the judge has the final say. That's why they focus so much on details, housing stability, job prospects, family ties. It's not just about proving innocence, it's about proving worthiness for a second chance. That human layer, that's what makes this all so powerful to watch.
That has all been resolved. This is now the only thing that's holding him in Washington County Jail. So I would ask this court to order him to pay the $75 when he's
Already
released.
did that. That didn't seem to work.
When he's really well, I will say at the time he did do 10 months, right?
Yeah.
And he's been in here. How much time have you been in now?
2 weeks.
Okay. So I don't know if you're gonna work when you get out, but order him to pay that and and give him a personal bond. That's my request. I'm sorry. I'm just.
Does he have anybody that can pay the 75? Because realistically, that's what I want.
Yeah.
Because that's restitution. So if he can get somebody to pay the 75, the 125 is just there, but I'd release him.
He says he can pay the 75. You can have someone come up here and pay it as your bond.
75?
Yeah.
Not at this moment. So, I mean, if you want me to do some time on it, I could do some time on it because I got a parole hold.
No. I can't have you do time
On this.
in lieu of restitution.
Well, all right. It's kind of complicated because I got a parole hold right now for Arizona. So when I leave here, I got to go out there to finish my time out there. So I got 5 months parole left out there. So I got to finish my parole out there.
Okay, so here's what I'm asking. Is there anybody that can pay the $75 for you?
Right now, no.
At any point?
At any point, yeah. But not right now, not at this moment, though.
Define moment.
Like, when do you think you could get it paid?
As soon as I get out of here, shoot.
Yeah, but when you get out of here, you got to go to Arizona.
Yeah.
And then we're going to be right back in this boat because the 75 won't get paid.
Well,
The victim's been waiting for 5 years.
Yeah. Shit. I mean, when I get out, I'll be able to pay it when I get out. You know what I'm saying? I can't pay it right now. You feel me? Like, I gotta go take care of that, and then I'll be able to pay it. I don't even live out here, to be honest. So when I get out, I'm going back to Arizona, finish my parole, and I'll be able to pay it somehow. I ain't been out here in like 6 years, 7 years. Like, I don't even live out here.
Well, Your Honor, are you gonna be in custody in Arizona? Or you just,
Yeah,
okay.
because I just did 3 years in prison, so I gotta finish like 5 more months.
Well,
But I'm gonna be able to pay it at some time though.
Yeah.
I'm not just not gonna pay it. I was incarcerated. I've been incarcerated in prison for 3 years, so I haven't been able to catch up on things. You know what I'm saying?
yeah.
Yeah, like I just got out last August, so
Well, given all that, Your Honor.
Anybody he can call to get the $75? That's all I'm looking for in this case.
Yeah.
I mean, the 300, the other part of that, I mean, I'll waive the $100, the other part of that. Because I get where he says that he's been in, but the statutory fee will just sit there. I just need the restitution paid.
Any family members? Anything?
yeah, I can get it paid.
All right, here's what I'm gonna do. have him make some calls, do something, see if we can get the 75 paid. I'll adjourn it out 1 week to May 12th, 2025, 1 p.m. Court does call the case, People versus Jeremiah Driscoll.
Ally's in on behalf of the people. Assistant Public Defender Natalie Pate with and on behalf of Mr. Driscoll, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Jeremiah D. Driscoll.
And Teresa Claire on behalf of probation. Your Honor, Mr. Driscoll is before the court for a review hearing. The victim is present and would like to address the court. She would like to ask that the no contact order and the no go to order be lifted. I know that she did request this from the court prior. However, the court would not consider it until Mr. Driscoll got engaged in DV programming. He is attending and compliant with that program and compliant with his payments and reporting to probation. The victim, Kanisha Pruitt, is present. Would the court like to hear from her?
Yes, absolutely. Hello.
Hi, Judge Simpson.
What's your name?
Anisha Pruitt.
All right. What would you like to tell?
We need it lifted, the restrictions. I actually get birth in 10 weeks.
Pardon?
I get birth in 10 weeks.
10 weeks?
10 weeks. And I would like for him to be present.
You want him there?
Yeah. I don't have nobody else. I'm at work right now.
Okay.
So,
Okay. Is this your first?
no, this is my second in 17 and a half years.
Second and 17 and a half years.
Correct.
So that's like a first.
Yeah, it's like the first.
Okay. All right. You know, boy or girl, or
It's a boy.
it's a boy.
Mm-hmm.
Hope he looks like you. No, I'm just kidding. I'm just messing with you, Mr. Driscoll. All right. Do people have any objection?
Your Honor, I'll leave it in the discretion of the court.
All right. What I'm going to do, Mr. Driscoll, so that you understand, I'm going to grant the request. You understand that, sir?
Yes. Yes, Your Honor.
All right. So it's going to be a no contact. I'm going to delete that. I'm going to add a provision of no non-consensual contact, meaning that if she doesn't want you around, then you've got to leave the area. You understand that, sir?
Yes, Your Honor.
All right. Very good. All right. Thank you.
Now, Judge Boyd is pressing for specifics, dates, charges, timelines. He's not here for vagueness, and when he turns to the state for clarity, you can hear the precision in his questions. It's not about being tough, it's about protecting the integrity of the process. These moments of scrutiny are how you separate speculation from fact. The courtroom doesn't deal in vibes, it deals in verifiable truth.
Yeah. Without objection.
Thank you, Your Honor.
All right. Thank you.
Thank you, Mr. Driscoll. You're all
All
set.
right.
We return to Natasha Odell, and things are unraveling fast. The judge confirms that the alleged new offense could be filed within days. That leaves Odell in limbo, caught between what she might be charged with and the punishment she could face for it now. For anyone who thinks probation is a free pass, this is your wake-up call. One accusation can flip your entire life.
Probation's recommending the officer continue with the next review hearing being set August 4th, 2025 at 1 p.m.
Hearing no objection, so ordered. Court does call the case of the People versus Clark.
Alexander on behalf of the people, Your Honor.
Shane Clark.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Clark, who is now approaching the podium.
Those emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion. I believe the defendant was arraigned on May 1st and was given a personal cognizance bond. And this was against people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim defendant argument, he called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. She also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right.
free healthcare. My daughter's safe with your mom. Keep fucking playing CUNT. I promise you don't know how real I am. And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions, in this one case, to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, call the cops, I don't give up, I'll murder your ass the day I get out. And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior. What could happen to her given that he's out with on a PR?
It's worth noting how Judge Boyd balances patience with firmness. When Odell starts to speak, he allows her to explain but also reins her in when she veers off track. This isn't about shaming defendants, it's about clarity, structure, and due process. And it's why Judge Boyd's courtroom commands so much respect both inside and outside those four walls.
It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled.
Now things escalate. The prosecutor confirms they are moving forward with charges against Odell, and suddenly everything shifts. The possibility of continued probation starts to fade. If the charges stick, she's likely headed for revocation. This is the moment when second chances start slipping away, and you can see it on her face.
Have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond. He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety and fight.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where is the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
It's by the Miller and Maple Park and Ride.
Judge Boyd doesn't rush. He considers everything: previous conduct, current allegations, legal standing. Then with a steady tone, he resets Odell's case pending formal filing. That move might seem small, but it gives both sides time. For Odell, it's borrowed time. And sometimes borrowed time is just enough to change the outcome or seal the fate.
I do have a letter from that social worker here, if you'd like that, Your Honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark get arrived at the court today.
The only address I have is a South Line address. Is that a correct
I
statement?
believe so, Your Honor.
How do the defendant and the alleged victim in this case, how do they know each other?
Your Honor, I believe they have been in an on and off relationship since January of 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
We're nearing the end of the docket, and you can sense the emotional fatigue in the room. These aren't just names on a list. These are lives in limbo, people fighting for freedom, dignity, or simply a break. Courtrooms may be procedural, But what happens here ripples far beyond these walls. If you're still watching, this is why it matters.
Mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
Born in 2019.
The defendant's not working.
Let's give credit to the courtroom staff. Every voice you hear, defense, prosecution, clerks, deputies, they're part of a machine that runs on high stakes and limited time. In this session alone, we've seen plea deals, bond arguments, probation violations, all filtered through one judge, one bench, and a clock that won't stop ticking. It's an organized storm, and they weather it daily.
Hard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
Are you the only one out there at that site?
Yes, sir.
Let me see, counsel.
And just like that, the session wraps. Some defendants walk out relieved. Others head back in cuffs, every one of them touched by a legal system that can be just harsh, slow, or redemptive all at once. What would you do if you were in their shoes? Would you take the plea, fight the charge, or fold under the pressure?
I'm going to leave you on the DPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay?
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone is all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this.
If today's docket showed us anything, it's this: justice isn't clean, it's messy, emotional, and deeply human. Judge Boyd's courtroom gives us a front row seat to those moments of reckoning where lives can change in minutes. If you found this breakdown powerful, hit that like button, subscribe for more, and drop your thoughts in the comments. What would you have done differently if you were the judge? See you in the next case. Welcome back to the courtroom, where today's docket is stacked with high-stakes evictions, legal confusion, and emotional testimony that'll make you question the system itself. From tenants in financial ruin to landlords demanding justice, this courtroom session doesn't hold back. In one case, a woman fights eviction after shattering her kneecap on the property she was renting, claiming the landlord was negligent, while the opposing attorney argues rent is rent, injury or not. Elsewhere, we see a mother balancing school, a lost job, and court confusion while still trying to negotiate a payment plan. And in the opening scene, a technical legal issue completely derails a landlord's attempt to evict tenants owing nearly $10,000. You'll hear misunderstandings about legal notices, dramatic pleas for mercy, and judges trying to maintain order in a courtroom full of desperation. Stay tuned, because these are real stories, real consequences, and real people just trying to survive. So buckle up, because this courtroom session doesn't just serve justice, it exposes the raw truth behind every unpaid dollar.
And the problem relates to the notice to quit. Because the notice to quit is terminate the tenancy, but the claim that you have is basically a rent claim.
It's actually including in the lease. I asked that we had a supplemental judgment on that, but the lease, well, my glasses here.
I don't think that you can do that, though.
Okay,
If the claim is for not paying rent, then one would have to file a non-payment of rent
it
action.
says under the lease, the lessee agrees that the lease agrees that the lessee's failure or refusal to perform according to the terms of this lease agreement will allow the lessor's option to terminate this lease and begin eviction proceedings. That's specifically in the lease.
I don't doubt that, but it can't be terminated like that. There are two separate sort of avenues. One being a non-payment of rent, one for others, non-payment of rent, and then termination of tenancy. as a whole without the option to redeem. When it's a non-payment of rent, part of the remedial measures is that the tenant has the ability to redeem. And so I don't know that I can do much with this case, because along the lines that you're asking me to terminate.
File a 7-day notice to quit.
That's what's going to have to end up happening. I don't think, based upon this, that the court has subject matter.
And here it is, a classic courtroom curveball. The judge throws out the entire case for lack of subject matter jurisdiction. Why? Because the landlord filed the wrong type of claim. In landlord-tenant disputes, if you're asking to evict someone for unpaid rent, you need to file a non-payment of rent case, not a general termination of tenancy. Each claim has specific requirements, and missing just one detail, like a proper 7-day notice, can collapse the entire case. This is a textbook example of how legal technicalities matter just as much as the facts. What do you think? Should courts be this strict, or does it protect due process?
I need to see her about.
Pardon?
Is there something I need to see?
Yeah, if you talk to Ann, she'll update you on what we found out. Barnes and Barnes versus Contavious Scandrett.
I was speaking for the plaintiff, Your Honor.
And also Christopher Mayo.
Mr. Mayo made representations the last time that he was going to get us paid fully.
Yes, and has not.
He is not. And he's not here, and so I'm going to raise my right.
You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead, sir.
We checked the ledger as recently as about 45 minutes ago, and the number is for rent is $2,335.34. That's 2335.34. $250 in costs for 258534.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested.
Here we see the court granting a default judgment, a win for the landlord, but with a catch. The tenant has 10 days to redeem by paying in full. That redemption period is legally required in many non-payment eviction cases. It's one of the few lifelines tenants get, a final chance to save their housing. But the clock starts ticking the moment judgment is entered. If you miss that 10-day window, eviction becomes almost inevitable. These nuances aren't always explained well to tenants. Do you think that's fair? Let us know in the comments. Should tenants get more time, or is 10 days enough?
I'm still waiting to hear back from SER. I talked with Hawk, and they are out of funds right now, but they have me on their list. And I'm working with family to try to secure anything, and still interviewing for jobs. I lost my job in December. I lost all my income source in December, right when I moved in. So.
All right. So the problem that we're going to have here is I've given the adjournment for the filing of at least a claim that you're seeking assistance.
Mm-hmm.
I don't have anything. There's not a dispute at all as to what's owed. So what I'm going to do is I'm going to issue a judgment finding no tribal issue in your hearing. I'll issue a judgment for possession and money in the amount paid for $5,460.87. What I will do, since you're waiting on Hawk and I'm not sure where they are, the normal writ date would be the 23rd. I counsel over the objection of plaintiff. There's no writ until the 30th.
Yeah, the week ends on the 29th. So,
Judge, why would you assume I would have objected?
You're right. I didn't, but in case you did, I was taking a preemptive step.
Thank you, Your Honor.
Thank you. Thank you.
Judge, we'll submit that.
All right.
Bye-bye.
Bye-bye. Northfield Estates versus Tamara Coppins.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, your name?
Tamara Copens.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
This is where the emotional weight hits like a hammer. Tamara Coppins isn't just behind on rent. She's pleading with the court after falling on the landlord's property, losing her job, and trying to recover with no income. She admits she doesn't fully understand legal terms, didn't know how to set aside a judgment, and is desperately hoping the judge will let her make a payment plan. But here's the catch. The court doesn't decide who's right morally. It only rules on legal requirements. This moment is raw, painful, and real. Would you rule with compassion or by the book?
But I'm locked to make them.
And
let me stop you there.
sure,
This is a motion to set aside the judgment which you filed.
okay,
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
yes, I can.
Okay, so why?
I went to the courthouse, and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money into an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them.
And this is the brutal part of civil court. Empathy doesn't equal legal relief. The judge tells Ms. Copens that unless she proves both good cause for missing court and a valid legal defense, her motion fails. Even though she fell, lost work, and tried contacting the court, she didn't present a legal reason not to owe rent. That's the hard truth. This is where many pro se defendants stumble. Emotionally compelling stories aren't enough. You have to meet exact legal standards. Do you think courts should offer legal interpreters or support for people without attorneys? Drop your thoughts below.
The whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know. That's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them
Because there's probably more owing now.
Oh, I'm sure that there is.
And Your
How
Honor,
much is owing?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations, but there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for a plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out, and I made
my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what notarious means. I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a job at the NFPA.
Okay.
So why can I not make a payment schedule, like $1,000?
Ma'am, that's gonna be something that has to be negotiated between the parties.
That's what I tried to do.
Okay, but if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years, and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court.
Ma'am,
I'm
asking
confused.
the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning, 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both,
Frankly,
I've done none of those.
You have to show me both of those, and neither of those have you shown me.
I did.
We had gotten a call, and it sometimes does happen. I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did
that day.
You did
saying, "Ma'am, I don't have a record of that."
I sent it to the court, and you emailed me back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you pay $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're going to go the 13th. So you're telling me to show you something that
told you that.
I have my phone. I have your emails. I have it from your courthouse. Maybe not you directly.
I can.
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside.
This one is wild. A misworded email from the court says motion granted when it really meant a motion hearing was scheduled. This created massive confusion for Ms. Coppens. She thought her eviction had been paused, but legally, nothing was officially set aside. In high-stakes eviction cases, even a poorly worded email can cause irreversible harm. Imagine believing you're safe, then showing up to court only to be told you're being evicted after all. Should courts be required to use plain language in communications? What safeguards should exist for tenants navigating legal systems alone?
I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Dornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous, Your Honor. The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent. It indicates motion hearing. And I'm looking for the attachment.
I'm looking at it now, actually. I'm looking at our notice that would have gone out. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied. The judgment will stand. And a writ
So
may issue.
you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay.
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
Okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't, I will get it.
Here, Ms. Copens asks a heartbreaking question. Can I pay today and stop the eviction? And the judge's answer, technically maybe, but only if the landlord accepts it. This illustrates how power shifts at this stage. Once judgment enters, it's not just about the law, it's about negotiation. If the landlord refuses to accept payment, the court can't force them. So even if you gather the money last minute, it might be too late. That's terrifying. Do you think judges should have more power to enforce payment plans when eviction is imminent? Let's debate it in the comments.
Thank you.
Well, I guess you're welcome. All right.
Court calls the case of River Ridge versus Kaylee Hamill Little. Hello.
Hi,
What's your name?
Kaylee Hamill. It's no longer Hamill Little.
Divorce?
Yes, thankfully.
Don't smile. No,
It's a
just
good-
don't smile. Okay, fine. All right. Okay, what is the claim at this point in this case?
No, Your Honor, $1,748.
All right. And how are you intending on getting that paid?
So I have a couple questions because there were court fees from the last time that were added on after every payment was made. Like we were here March, I think it was.
Okay.
And everything was paid up and then they added court fees on the following month and then denied a payment. It was really weird. So I'd called, spoke with management about it. There's no longer a manager at that location, so they had to call who's ever overseeing it. And then it took days to get back. So I was very confused. And when they explained it to me, it didn't exactly make sense. So my ledger didn't add up and I'd already paid April's rent. So that ended up showing up late. It was a whole fiasco. And all in that time, I lost my job because of nursing school. So I've been fighting with unemployment.
Got it.
So I literally just had like a court hearing judgment, something along those, I don't know the technical term, yesterday that was canceled because my old job stopped protest. I'm not sure.
So are you telling me you can't pay this amount? I'm sorry, Miss Dornbush, you were going to say something.
Your Honor, yes. At the last court date, Ms. Hamill did raise these issues and Judge Barr advised her to either call management or to call me to discuss. I don't know if she spoke with management or if her conversation with management took place, but she referenced took place before or after the last court date. Your Honor, I can tell you that my client has credited court costs of $174 that were assessed in April. I believe my client's intention was to file suit in April. It looks like they did not. So they have credited those court costs. Ms. Hamill is, though, responsible for the court costs associated with this filing that occurred in May. So the
Got it.
$1,747 does take into account that $174 credit.
Yes, and that makes sense because the total figure given at the June 6th hearing was 1922. So
Okay.
they credited it.
Okay, so I can make a payment coming up Friday of 300. But like I said, I'm waiting on unemployment. I don't.
When do you think your unemployment's gonna hit and then they're gonna have a retro check to you? But you don't know.
You're more acquainted with the state of Michigan than I am when it comes to that.
Probably not, but
I also am
go ahead.
in the process of the hiring at another hospital that is working with school schedules. So,
All right, here's what I'm gonna do. There's not a tribal issue. I'm gonna grant a judgment after a hearing on this matter for that amount of the 1748. What I will do, because they can't wait on that, so you can pay the 300 to them. That's at least gonna reduce your balance, okay? And then if you get your unemployment in any retro, then you'll be able to do that.
yes.
I will have a writ to issue. It would normally issue on the 23rd over the objection of plaintiff if she's waiting on unemployment and I get it. I will go to the 30th. I'll give her an additional week because if she gets her unemployment, then it's going to be getting them to send that other check. So
Right.
you get that. So, all right.
Okay.
That's over plaintiff's objection. But
Thank you.
Okay.
Your Honor.
So I have until the 30th.
you have until the 30th,
Perfect.
but get the 300
300
into
next
them right
week,
away.
right.
Okay. But that gives you a little bit of relief.
Okay.
All right. Thank
Yep.
you. Scio Farms versus Derek Wanshan. And Elizabeth Wanshan. Hello.
Hi.
What's your name?
Elizabeth Watson.
Wanshan. Okay. And what is plaintiff's claim in this case? This is also yes, go ahead.
$29.05 and 46 cents.
905.46. All right. And ma'am, how are you intending on getting that paid?
I wanted to ask today if we could pay this full balance at the end of the month, the 27th.
Will you have it by the 27th?
Yes.
All right. So here's what I'll do. No tribal issue after a hearing. I'm going to grant a judgment for possession. Okay.
Okay.
In that 2905.46. You say you'll have it the 27th?
Yeah.
Normal writ date will be the 23rd. I'll indicate no writ till the 27th.
Okay.
That'll give you time to get it paid.
All right.
All right. Thank
you.
you. Spice Street Apartments versus Samuel Bishop. Samuel Bishop, there is no response. You had previously been sworn. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,584.74, costs of $169 for a total due of $3,753.74. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Spice Street Apartments versus Stephen Shelton.
Yes, I'm here.
Your name, sir?
Stephen Shelton.
All right, you got him. All right. That's not a phone, is it? I'll need a camera if you can get that. But what is plaintiff's claim?
Rent to retain, I'm sorry, Your Honor, the total with court costs is $2,921.69.
All right. Mr. Shelton, how are you intending on getting that paid?
I'm making a payment later today, and then I'm gonna pay the rest next Friday. So by next Friday, it should be all paid.
So by the 20th?
Yes, correct.
All right. So here's what I'm going to do. I'm going to find no tribal issue after hearing. I'll grant a judgment for possession in the full amount of $29,21.69. And that is to be paid by the 23rd, that Monday after that. Okay. So that's your statutory period, but it
If you get it paid by the 20th, you'll be good. Okay?
Okay, sounds good. Thank you.
Thank you.
All right.
Valley Ranch versus Brandon Kuchar.
Brandon Kutcher, hi.
All right, hello. All right, what is plaintiff's claim?
With costs, Your Honor, $4,676.45.
I'm sorry, give me that number again.
46.76
45. All right, sir, how are you intending on getting that paid?
We were trying to get it paid by Wednesday, 2 days ago. We were unable, but we'll be able to make payment in full through the rent payment portal online this weekend. We want to get it paid before Monday. I think then that adds another $100 on Monday. So we'll submit it before Sunday evening.
In any event, you'll have it paid before the 23rd, correct?
Yeah, absolutely. If you have to issue the judgment and then that can be set aside, that's fine. We've had to go through this before. We will have it paid in full before the 23rd.
All right, judgment to the, I'm gonna find no tribal issue after a hearing. There's no dispute as to the amount. Granted judgment for possession with a writ date of the 23rd. And then get it paid, you'll be all set and you can negotiate to set aside. All right? Okay.
Thank you very
sir.
much, Ms. Dornbush.
All right. And I think, is that it for you, Ms. Dornbush?
It is indeed, Your
What a ride. From dismissed cases to desperate tenants begging for mercy, this courtroom session laid bare the harsh realities of eviction law. We saw technical errors ruin legal cases, heartbreaking stories brushed aside due to procedure, and families trying to hold on to homes that have been in their lives for decades. But through it all, the judge remained firm. You need legal grounds, not just emotion, to stop an eviction. Whether you agree or not, one thing is clear: housing court is fast, fierce, and unforgiving. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Because in this courtroom, every second counts.
Waiting for a check to clear, so Monday or Tuesday, whenever that check is cleared, and it'll be paid in full.
It'll be paid in full.
Mhm.
So certainly by the 20th, you'll have it paid in full.
Most definitely, yes.
All right. I can do it one of two ways. I can grant you the judgment at this point, counsel, or I can turn it out to the 27th. Which would you prefer?
You know what, Your Honor, I'd rather not have to come back if we don't have to. Usually I'd say I'm just getting killed with these court dates, Your Honor.
I hear you. Me too.
So if we could just do a judgment and
all right,
and
then if it's paid, would you agree to set it aside for her?
if she requests a set aside and lets me know, I will do it.
Okay.
Yes.
We'll do it that way. Finding no tribal issue after a hearing. Judgment to the plaintiff in the amount requested of the $29.94 even. All right.
Great. Thank you so much.
Writ date the 23rd. So get that paid and then you'll be all set.
Yes, thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of Six Trails versus Jordan Oren.
Good afternoon again, Your Honor. Sidney Katz, on behalf of plaintiff.
That was nice of you to say close enough, but butchering names all day. Your name?
Jordan Oren.
All right. Well, I said it kind of close.
Yeah, it's close.
All right. All right. What is plaintiff's claim in this case?
Balance including costs totals 3,117. 3,000.
All right, sir. How are you going to get that paid?
So my dad is willing to help with a significant portion, and I actually just started work again at the start of this month. So I will get paid on the 26th of June, and mixed with what my dad is willing to help with, it should be able to cover the full cost by the
27th, 27th, Your Honor,
26th.
just to give him a little cushion.
Sure.
All right. So no tribal issue after a hearing. I'll grant a judgment to the plaintiff in the total amount of the 3117 and writ date 27th. All right, June 27th. All right.
Okay, sounds good. Thank you, Your Honor.
Thank you. Court calls the case Willow Ridge Apartments versus Angela Schmidt.
Good afternoon again, Your Honor. Sidney Katz, on behalf of plaintiff. I think there she is. She's on Zoom.
There she is. Ms. Schmidt.
Hello.
Hello. All right. What is the plaintiff's claim?
Balance including costs 4,311, $4,311.
Ms. Schmidt, when are you going to get that paid?
I was supposed to make a payment by today for $1,000. I tried to go online to make that payment and it wouldn't let me. So I was going to drop it off at the front office, but I wanted to make sure that that was where I should drop it off at prior to me doing so. So I have the $1,000. I'm just waiting to find out what my step is supposed to be. And then the remaining balance
by the end of the month?
No, 27th, that'll take it pretty much till the 30th at that point.
Yeah.
27th is fine.
All right. A grant judgment to the plaintiff finding no tribal issue after a hearing for the amount of the 4311 and writ the 27th.
All right.
All right.
And then,
Thank you.
um,
Yes, ma'am.
the $1,000, do I just drop it off at the front office then, since I can't do it online? It won't let me do it online?
Whenever, however you pay it, you just have to pay the full amount by the 27th. There's no
Okay.
requirements of any specific amounts by any date. As long as you pay the full amount by the 27th, you're good. All right?
Yeah, no, she's trying to figure out where she takes it because I think the portal's probably shut off for her. but
Yeah,
you may
the
not
portal's
know.
shut off. You probably have to find out when the office is open and drop it off there. Give them a call.
Okay.
Just make sure. Okay.
Okay. And I'm
Thank
sorry,
you,
can I
ma'am.
have the total one more time?
4311, $4,311.
Okay. All right. Thank you so
Alrighty.
much. Have a good
Thank
weekend,
you.
guys.
Have a good weekend.
Thank you.
Willow Ridge Apartments versus Woods Edward.
Edward here, sir.
Is it Edward Woods?
Edward Woods, yes.
Okay, I don't know.
I don't know. We keep on doing it this way, Your Honor. I have no idea. This is the only one. It's like the third time I've seen
Yeah,
this.
that's what's on the documents
I
too.
know.
Okay.
It's coming from
Edward
us.
Woods. Okay.
Your Honor, we did submit a proposed consent judgment to the court last week.
Yes. All right. And Mr. Woods,
I'm here, sir.
you signed the consent judgment indicating that you're going to pay a total amount of $5,030.
Yes,
Is that
sir.
correct?
Yes.
By the 27th. Do you have
Yes.
any other questions regarding anything on the judgment?
No, sir.
All right. Then I will enter that judgment. Sir, I do have to advise you have 3 business days to think about this judgment. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within that time frame. Doesn't mean that I would grant it, but you'd have that time to think about that judgment. You understand that, sir?
Yes, sir.
All righty. Thank you.
Thank you.
Thank you, Your Honor.
Bye,
Have a
folks.
good weekend. Your Honor, I was
All
ready.
right. You do the same, sir.
I was ready for that last woman at the 1 o'clock docket or the 12 o'clock docket. I think you need like an MC to call your next cases. It sounded like you were one of the TV judges. Next on Judge Simpson.
You might be right.
Have a good day.
All right. Thank you, sir. Cheryl Barksdale versus Leo Stringa.
Good morning, or good afternoon.
Good afternoon. Who do I have here?
I'm Sherelle Barksdale, my husband Marlon Barksdale.
You just brought him along. He just straggling. All right. All right. This is a termination of tenancy case. I don't have the defendant here. The defendant in custody. All right. There's no requirement that we bring them up. All right. Got it. And you were before Judge Barr. He disclosed that he had previously represented you, I think, on something. It doesn't matter. All right. And this is a termination of tenancy and there was a month-to-month lease. Is that correct?
No, it's a year lease.
Wow. Okay.
Lease violation.
Let's see. And then the notice, what are you claiming is the lease violation?
So in his lease, there is, in section R, harassment, annoyance, and, of tenants. So I'm getting complaints every week about him.
Gotcha.
And then also, in the lease in.
I'm gonna have to stop you, okay? I'm looking at your notice to quit. Everything else looks like it was done correctly. The notice to quit, however, was not done correctly. That's what gives the court jurisdiction to issue a judgment for you. All right. And I can tell you specifically what's in error on it. And that is that, I don't know, do you have a copy of your notice to quit in front of you?
I have the summons and.
You go back, because you filed the notice to quit, right?
Yes.
Well, anyway, at the very top, it says that your landlord is seeking to recover possession of property pursuant to, and then there are 2 check boxes. You have to put information as to why you're terminating. Yeah. So the second checkbox, which is the other, would be what you'd be describing to me.
Oh.
But, and I usually don't go through this with people, but
You have to do that because they have to have a notice as to why you're doing it.
Okay.
Follow me?
Mhm.
Okay. And so since you haven't, I hate doing this, but since you haven't filed a proper notice, I don't have jurisdiction to do anything except dismiss the case. Okay. So that's what I'll do. Because I lack subject matter jurisdiction, and I will dismiss this case. All right. Hold on one second. All right. And that's the last case that I.
Yes.
All right.